Okay, so welcome everyone to the Business 911 Roundtable. This one today, let me make sure I get the title right. We are going to be talking about the 11 expensive legal mistakes entrepreneurs make and how to save yourself a boatload on legal fees by not making them or by fixing them fast. So this is going to be presented by Michele Kelsaw with MK Legal Planning. My name, by the way, is Scott Jones. I'm with the Marshfield Grow Committee, and her shoe was out of country right now, so he asked that I go ahead and facilitate. So if you have any questions, you can shoot them my way relative to getting the meeting going, or if you have any technical issues. Otherwise, I'm going to go ahead and introduce Michele, and we'll get things moving along. So Michele is an attorney for let's start over. Attorney Michele Kelsaw's practice focuses on proactive approach to law. Michele uses the law to assist clients in developing legal strategies to ensure that their families and businesses are well taken care of during their lifetime and beyond. Michele graduated with her bachelor and master's degree in business administration from Stetson University in DeLand, Florida. She then returned to her home state of Missouri to attend law school. She graduated from Washington University School of Law in 2009. She worked for a small firm prior to opening her own law firm in 2011. Michele has chosen to devote her practice to business planning and legal strategy because it provides her with the opportunity to assist clients with growing and strengthening their businesses. Michele is a third-generation small business owner and entrepreneur. She shares the same passion for small business as her parents and grandparents before her. Michele nurtured this passion in business school before obtaining her law degree with the goal of using these educational foundations to work with her favorite people, entrepreneurs and small business owners. Michele is licensed to practice law in Missouri. She is a member of Rotary, Rolla Chamber of Commerce, Salem Chamber of Commerce, Rolla Downtown Business Association, and Coterie. Most importantly, Michele is a proud mother of a precious little girl. In her spare time, she enjoys spending time outdoors with her family. And so without further ado, I am going to stop sharing my screen and we will let Michele take over. Welcome, Michele.
Thank you. So I am Michele Marxkors Kelsaw, and I have a law firm based out of Rolla, Missouri, but my husband and I live in Salem. So we split our time between those two places. And today we're going to talk about the 11 expensive legal mistakes entrepreneurs make. So bear with me. I don't know that we will reach all of them, but we'll do our best, and then I'll give you some resources to follow up. My understanding is that Scott's going to help me coordinate so we can be interactive on this. So if anyone has any questions, please use the chat function to send those to him, and he can interrupt me, and I can try and answer questions on any of these topics. So the first thing I want to say before we go through them, in the materials that you should have in front of you, you have the article that we're going to talk about today, the 11 expensive legal mistakes. You should also have what I call the business health check, okay? And so the first thing I want to say is as you read through those two things, I do not want anyone to get panicked or feel a sense of despair or anything like that. Nobody is perfect on these things. Okay, and so I like to just remind my clients of that before I get started, or any group that I'm talking to, that this information is supposed to empower you and allow you to develop a legal strategy. So we do our best, we talk about the best efforts, the best practices, and we move forward from there, and we don't panic and run out and think that somebody's going to sue us and take everything we own, or get any kind of despairing thoughts like that. So thoughts of despair like that. So let's go ahead and get started. The first expensive mistake, number one, not choosing the right legal entity. So there's a couple different things that people do wrong here. The first one is not having an entity at all. And what do I mean by entity? I mean something that the law will consider is separate from yourself, something to give you protection. So the most common ones are LLCs, are limited liability companies, but most commonly we refer to those as LLCs. And the other one that people are most commonly familiar with and most commonly used are corporations, okay? The number one reason to have one of those structures is to protect your personal assets. So we call that a liability shield. What we're doing is we're drawing a line between Michelle's car, Michelle's bank account, Michelle's retirement account, whatever it might be, my house, and my business assets, so that if anyone were to come sue me, I have that protection. So if somebody comes to sue my business, the idea is that if I've done everything correctly in forming and maintaining those structures, that there will be a shield there, okay? There are limited circumstances when that shield can be what we call pierced, but the foundation is to get a legal entity properly registered and properly up and running and maintain it. Okay, so where people screw up on that the most. Number one, the thing I see, oh my goodness, at least a couple times a month. A lot of people do not understand what they need to do to form a legal entity. So the first mistake I see people do is jump on the Secretary of State's website and file what we call a fictitious name registration. So that's the fancy name that the Secretary of State gives, but that would also be commonly referred to as a DBA, or a doing business as, okay? So a lot of times people jump on the Secretary of State's website, fill out the form. It's a simple one-page form saying, I'm going to be doing business as, and they list their company name. They put themselves as the owner. That gives you no liability protection, nothing. There's really no legal reason to do that. It's the same as if you're putting yourself out there as Michelle doing business. They can still get to everything I own. And people really don't understand that. So that's number one mistake I see people make. Number two, if you form a limited liability company, an LLC, you will file what they call the Articles of Organization with the Secretary of State, and it will not clue you in that there's more you need to do. So the law actually says, the law in Missouri says that we need to have what we call an operating agreement, okay? The bigger reason you want to have an operating agreement is to try and prevent disputes, if there could be any down the road, and to give you that liability shield. So a lot of people jump online and file the articles, which again is a one-page document. They don't take time to consider what the form says and the implications of the things they're answering in the form, and they don't do anything else because the state doesn't tell you that you need to do anything else. So if you have a limited liability company, you want what we call an operating agreement. And you really should try and work with an attorney to draft a proper operating agreement. And I will tell you, I get people in my office all the time who have other attorneys pull a form for an operating agreement. Don't talk to them about it. Don't explain it to them. And it really is not serving them any purposes. If you are a corporation and you jump online and file those articles of incorporation with the Secretary of State, you do have to do more. So you need to have what we call bylaws. All right. So same idea there. We need to have governing procedures. We need to revisit those. So let's talk about it. The first step is you need to have an operating agreement if you're an LLC, or you need to have bylaws if you're a corporation. The second step is we need to be careful about what we put in them, and we need to follow them. So I'm an attorney. If I go sue a business, what I'm going to do is I'm going to ask for all these documents, and I'm going to get them. And if you don't have them, I'm immediately going to go to the judge and say, Judge, they're not really operating as a business. Let me, what they call, pierce that corporate veil. Let me get to any and everything that they own. Okay, so it puts your assets at risk. The other thing, even if you have an agreement, I'm gonna get it during the court process, and I'm gonna look through it with a fine-tooth comb, and I'm gonna see, are they following the procedures that are in their bylaws of their operating agreement? Okay, the most common ones that people fail to follow are what we call the corporate formalities. So if you say in those documents, if it says you're gonna have an annual meeting, you need to have that annual meeting, and you need to write down the minutes for it, and it needs to be with your company records. Okay, that's kind of one of the most common ones we see people trip up on. But anything that's in those documents needs to be followed, or again, you're putting yourself at risk. So those are kind of the big basic things I see with choosing the right entity. The other thing I'll mention before we move on to the next bullet point, if nobody has any questions, is that if you are working with an accountant or a CPA, and I recommend that all of my clients have a very good CPA that they also work with, you will hear that person use terms differently than me as the attorney will use them, okay? So I'm gonna just walk through the most common time that this happens. If I have a client who has an LLC, they are legally an LLC. I don't want them to tell anyone that they're anything different. What happens is they go talk to their accountant, they look at their tax returns, they're having conversations with their accountant. That person's telling them, oh, you're taxed as a partnership. Oh, you are a partnership. You are an S corp. You know, these kinds of terms fly around. They are actually not a corporation or a partnership. All that means is they're making certain tax elections. So it gets very confusing. An LLC can be taxed as a sole proprietor, a partnership, an S corp, and so that gets confusing as well. So just something to be careful about, and make sure you have advisors both in the accounting field and the legal field that will communicate with each other and make those things clear to you. Okay, and I guess, Scott, you clue me in if there's any questions on number 1, and if not, I'll move on to number 2.
So far, no questions. Anybody want to raise their hand? Okay, we're good.
Okay. So number 2, not documenting agreements. So a lot of us are in, what's considered, especially on the national scale, of smaller towns. So a lot of times we know the people we're doing business with. Sometimes we're related to them. Sometimes they're our best friends. We might be inclined to want to try and do things on that handshake basis. What I tell my clients, and part of what I need to do to educate our community, is to let everyone know that the best practice is to get something in writing. Okay? The very best practice is to get a business attorney to give you something in writing so that they can issue spot for you the things that need to be in those documents. If you cannot hire an attorney, though, the minimum is get something in writing and have you both sign and date it, okay? And I think the best way to illustrate this point is just to walk you through a couple of real-world situations that I have had to help people with. So these are instances where people came to me after the fact and did not have written agreements or did not have an attorney, a business law attorney, do their written agreements. So I had the unfortunate circumstance of working with a gentleman who had a business with his best friend. Everything was going fine. They hired an attorney to help them, but just did a basic, that attorney didn't really know what they were doing, gave them a basic bare bones operating agreement. It did not mention anything about what happens if one of them gets sick and is no longer able to serve in their role as an owner of the business. And in an LLC, we call owners and members. So what happens? Unfortunately, best friend has a stroke and cannot continue in the business. So the remaining member we'll just call Joe. Joe is stuck doing all the work by himself. And what happens is the incapacitated member, and we'll call him Jack, Jack's wife starts bugging Joe for her money. So Joe does not get along with Jack's wife. Jack cannot participate in the business anymore. They have nothing in writing about how that member could be bought out, what money's owed, what kind of contributions need to be made, and they're just in a mess. So Joe's stuck working 70-hour weeks, and he's going to have to figure out what to pay his best friend's wife and how to get that in agreement and get that signed off on and get her to withdraw. So that is not a scenario we want to end up in, and not something that you would ever expect. Best friends got along great, but the unexpected happened, and we end up with a disaster. A lot of times the only way out in those scenarios is lawsuits, and that's thousands and thousands of dollars in legal expenses. That's Joe running the business by himself the whole time, with part of that benefit going to the best friend's wife, even though they're not contributing any work. And if anyone's ever been involved in court, it takes forever. So that's my story there. I have another one similar to that, where best friends went into business together, everything's going well, and then one of the friends, they put nothing in writing, and one of the friends is now doing things the other one doesn't agree with. That relationship has fallen apart. There's nothing in writing about how to dissolve that relationship, and they're going to end up spending a whole lot of money dealing with this and a whole lot of time. And the worst part is they're going to ruin their relationship. So even friends and family, I encourage people to get things in writing, because I have seen time and time again these scenarios play out. Okay. Expensive mistake number 3. Hiring, firing, otherwise handling team members incorrectly. So everyone should have an employee manual, and you should follow it. So remember, anything you put in writing, we need to follow. I advise everyone to have a manual and have a procedure. We all can understand, we see in the news every day, we're in a culture where people get sue crazy. They see, you know, some kind of lawsuit on TV, somebody gets millions of dollars, and they think that they could be next. And they will find an attorney to file a lawsuit, even if it's frivolous. So that's the unfortunate part too, why people don't necessarily like lawyers. So we want to be very careful there. The most common scenario that I encounter with business owners where we're kind of treading a line and we need to be careful with hiring and firing is whether or not to classify people as employees or independent contractors. So let me see if I can share. Okay. So if everyone can see my screen, I'll back up just for a moment. In case anyone wants to check, it's not a bad idea to go onto the Secretary of State's website, www.sos.mo.gov. When you go on there, business services, you can do a business search, okay? It's never a bad idea to go ahead and put your own business in there and double check what you've got on file with the Secretary of State, okay? Make sure everything's properly filed. You will also see there's an online business services portal. You can make a login, which of course I have one, and you can file various forms online. Just be careful, the state is not going to tell you what you might be missing or what the next step is going to be. And then they also do have a format, T's and forms right here, where you can print out any forms and mail them in, and they have them organized by subject matter. So I am on the Secretary of State's website just about every day. It's a good tool to get familiar with and to make sure you know what's going on. The other thing I was going to point out on employees, let's go to, if I can reach it. Okay, so on my website, I do have a blog, and so it's mklegalplanning.com, and there's a blog tab, and as far as classifying, the mistakes people make classifying independent contractors and employees, we don't have a ton of time today, but there is an article on there, September 27th, 2018. So if anyone is interested in making sure that they at least understand the basics of the classification, here it is right here, cost of misclassifying employees and independent contractors. The big scary part here is we can get in tax trouble. So that's why we should be worried. We never want the Department of Revenue or the IRS to be clued in on us or chasing after us for any reason whatsoever. So that's really a good resource to at least get the basics there. It will be a legal analysis if you have any questions on how you classify, as well as a good topic to have your CPA consult with as well. So let's see if I can do this. Stop the share. Okay. All right, so number 4, starting a competing business while still employed or even shortly thereafter. This really pertains to what we call intellectual property, okay? And there are some other contract provisions as well, so some other general breach of contract provisions. I want everyone, once again, you need everything in writing. So I want an employment contract or an independent contractor agreement for every person who would be working for or with your organization. As part of that agreement, you're going to have certain things in there. One of those could be what we call a non-compete agreement, okay? So, and then I'll take that full circle to intellectual property. So what we call intellectual property, or IP for short, are the intangibles that a business owns. That's the easiest way to think about it. The ones you're most commonly familiar with are copyrights and trademarks. There's another one, trade secrets, okay? And then just an overall, we can think of any confidential information. So when we have non-compete agreements in place, what we're concerned with is somebody taking that confidential information or intellectual property of your company and then trying to use it for their own benefit. Most commonly, we'd be talking about the customer contact list, right? And so if you have any concerns about this happening, you want that in writing in your employment agreements. And so people really don't necessarily think of that. This mistake is addressed to if somebody leaves a company thinking, I can do this better, I'm going to take all these clients with me. They need to be careful because they could end up in litigation. And depending on the size of the company, the more drastic the impacts on that individual can be. So there was a corporation that had a lawsuit like this going on with a former employee, and it was a large corporation. I can't remember off the top of my head, but just in the last 2 years, they spent millions of dollars on legal fees. So they drowned this former employee in litigation and legal fees until they just caved and gave up on their new business venture. Okay, so that's what we're talking about there in mistakes. So just be aware that if you are taking anything from a former business, you need to be careful and make sure that you are allowed to do that, and then it's not property of the business. Be aware as a business owner that that is your intellectual property and your intangible property, and you want to protect that. And so we need those writings in place. There's a mention about insurance there. I think I had something else on insurance further back, so we'll gloss over that for the moment. Okay. Okay, number 5 feeds perfectly into what we were just talking about. So, not protecting or capitalizing on your intellectual property. This is most commonly referring to those trademarks, those copyrights, anything anyone is developing for you. So, let's talk about the most common scenario I see people getting into trouble with this. If you hire a graphic designer or a friend, or if, let's say I hired Scott to develop my website or to do a blog post for me or graphic for me. If I do not have in writing that my company owns that, he automatically owns it. So let's just put it this way. In intellectual property, the person making that property owns it. If I take a picture, I own it. If I write a blog post, I own it. If I make a graphic, I own it. Okay, so the only way to change that default is to put a writing in place, to have a contract. Okay, and most people forget that step. And a lot of times we're using people we know for, make a logo for us or do something on our website. We need that documented if we want to make sure that our company owns exclusive rights to that. So we have to transfer that intellectual property right to our company. And most commonly what we are referring to is also make sure you have what we call work for hire clause in there, okay? And so what I've got here too, just to go in detail because I know we're limited on time today, if we go, I do have an article on that as well on that same page on the blog. It is July 31st, 2018. I had an article about protecting your copyrights and your intellectual property and your trademarks. So I also see people violating intellectual property rights and not really understanding. So a lot of what's popular right now is those craft fairs and vendor fairs and things like Etsy, and we all have a lot of fun and go buy pretty things. And what I see is people making things where they are actually infringing, which is the big word for violating somebody else's intellectual property. So if I make pillows and everyone thinks they're really cute and I'm at a craft fair and it's kind of the it thing around here and everyone wants to buy my pillows and I make them with blues and cardinals and whatever logos on them, sports team logos on them, Mizzou, I am violating the law. So I do not have the right to take Mizzou's logo or Cardinals logo or the Blues logo and put it on anything and sell it or reproduce that in any way. And so that's something I see happening all the time that people do not understand. The other thing that's frequently happening with my clients that I talk to them about when they get to me is a lot of people are paying somebody to make a logo for them, putting it all over Facebook, putting it all over their website, making t-shirts with their logo on them, and they do not have that documentation we just talked about to make sure that they own it. So if their business takes off and they really start making money on their t-shirts or anything with their business, the person who made that logo for them can hold them hostage and require them to pay whatever sum they come up with in order to be able to use it. So those are kind of our big things to look out for in intellectual property. Mistake number 6, weak or non-existent record keeping. So this goes back to the point I made in the beginning about what we call piercing the corporate veil. So if I am going to sue your company, I'm going to ask for any and every record related to your business, okay? And I'm going to get most of them. And the law says that you are required to keep certain documents with your company records. If you are not keeping the proper documentation, I can make an argument to the judge that you are not operating as a separate company, that you are what we call an alter ego of yourself. You're not actually separating your personal from your business, okay? That means that I'm going to have a good argument to try and get to your personal assets again, that liability shield's not going to work for you. The other thing that people do frequently while we're on this topic is they commingle personal and business property. So if you have a business bank account, do not pay your mortgage out of it. Do not pay your rent. Do not pay your personal water bill. Do not commingle in any way. I also see people writing, well, I see that happening all the time, and I don't think that's being adequately explained to people. So if you have a business and you want that liability shield, you need separate bank accounts, separate credit cards, separate records, have everything completely separate, okay? Number 7, expensive mistake number 7. This feeds perfectly into number 6, having an advisory team lined up for support. I advise my clients to have what we call LIFT, legal, insurance, financial, and tax. And of course, your financial and tax could be in the same place, but it might not be. So, of course, I recommend that everyone has a legal advisor and somebody that really knows what they're doing and that gives them a strategy to move forward, because you're not going to be able to tackle every potential legal landmine at the beginning, okay? So we talked some of the reasons about legal. So the next part of that is insurance. I recommend everyone have an insurance person that they trust. So we put the legal foundations in place to make sure that we do everything we can to protect you in the event of a lawsuit. We cannot prevent people from filing lawsuits. So we've heard them all the time, or I'm sure all of us have experiences or stories with people filing a lawsuit and what we would call a frivolous claim, something that really has no basis. We cannot prevent anyone from filing those, so the best we can do is have those legal foundations in place so that we can try and get those dismissed and thrown out of court as soon as possible or resolved as soon as possible. And then your backup is insurance. We want to make sure we've got insurance in place to take care of those things. So even if there's no wrongdoing there, we need insurance to make sure that our legal fees can be covered. So I worked with a company that decided not to have workers' comp insurance because legally they were not required to. You only have to have it if you have over a certain amount of employees. So legally they did not have to. They had a workers' comp claim. They have to pay me my legal fees out of pocket even though they thought the claim was invalid. What would have happened if they had workers' comp insurance and if they had a good plan was they could have had their legal fees taken care of through that policy and would have saved themselves a whole bunch of money and hassle and time. So we will always want to make sure we've got insurance in place as that backup. The next one is financial. And when I say financial, I'm really referring to the bookkeeping, the record keeping related to your finances. Making sure we have all those accounts separate, making sure we have bookkeeping systems in place. And if you are just more of a startup or very simple with your business, that can be in spreadsheets and different receipts organized in paper folders or however you need it. Obviously, as people get more advanced and grow in business, those will use different kinds of software, QuickBooks, or some of the other types of software, and maybe become more complex systems. But we need a system to make sure everything is taken care of. You also need a good tax advisor who knows how to deal with businesses and who understands enough to trigger when that's a legal question or a tax question. So remember we talked about commingling. A lot of times people will come to me after the fact and their accountant has told them to do something like put the, they say, oh, go ahead and put the company vehicle on your personal insurance policy and that'll save you some money. Okay, that tax person maybe is saving you some money. You can write it off as an expense, or maybe it's bundling and saving you some money, or maybe the insurance person says that. That's probably a better example of an insurance person saying that. I, as the lawyer, am telling you, you have just commingled. You've just opened the door for me to sue you and get to your personal assets because you've now commingled the personal and the business. So you just need to be aware that the team of advisors you choose should communicate with one another and should know enough to tell you when something falls in one of the other's wheelhouse. And tax is a big thing. I really recommend everyone works with a CPA or a tax attorney. And even further than that, somebody who actually deals with businesses. All of the clients I work with, I actually give worksheets of questions to ask when you're hiring your insurance, your financial, and your tax person to make sure that person actually knows what they're talking about and that they can help you. The same thing goes with lawyers. So all of these professionals work for you as a business owner or the person running the business. They work for you. So you get to hire us, meaning you get to ask us questions and make sure you feel comfortable with us and that we are knowledgeable and we can actually help you. And so that also means you can fire us and look for somebody else if you do not feel that we're giving the right information or something just seems off. So I encourage people to shop. Just not shop around, but do not price shop either necessarily, but make sure that the person that you are dealing with is educated about the topic area and that you can trust their advice. And so that does involve some conversations and spending some time with each of these people. I also think it's great to work with professionals who are able to communicate and willing to communicate with each other. If somebody's not willing to communicate with one of these other advisors, that's a red flag to me that they're really more of a salesperson. They're trying to get your insurance policy and then move on to the next one. They're not really going to help you or service you. Okay, expensive mistake number 8, jumping into a lease or agreement to buy land too quickly. This becomes very difficult for a lot of business owners, especially in the Raleigh area. We have one big property management firm that anyone from around here is probably familiar with who I'm referring to. And I'm not saying anything against them, but there's one company that really is controlling a lot of the real estate, even if they don't own it. And they have their own form lease agreements. When you are dealing with commercial leases, which is anything for a business, you need to be willing to negotiate. And I encourage you to negotiate. That property management firm, or if you're dealing directly with the landlord, if they want you in your building, they're going to sit down at the table with you and they're going to try and be reasonable. If they are not, you do not want the property. So I really encourage people to keep that in mind and really try and negotiate the terms of the lease and not jump into anything too quickly. The other mistake I see people making is they're taking on too much at the beginning. So there are a lot of businesses that are starting out and they see their long-term plan and maybe they want 6,000 square feet and, how are they going to afford it? We do have a resource here in Rolla through Missouri S&T. They have an entrepreneurial center and they do help people with what we call that budgeting or that cash flow analysis and that type of thing in the startup. And they do help people with that at no charge. So they're a great resource if anyone is looking to start a business. And I'll give you my contact information to follow up so I can put you in touch with somebody over there if you are curious. They help business owners work through those types of things, the work through budgeting and making sure they don't get in over their heads on a lease. The same thing with purchasing land, other than it is even more complicated when you purchase land. So even no matter whether you're leasing or purchasing, when you are a business, so if you're an LLC, for example, a lot of times that landlord or the lender who's giving you money to purchase is going to make you personally guarantee that. That's because the business doesn't usually have any assets, and even if it does, you can move those around into your personal account so fast that no bank's going to give you money without putting your personal assets on the line. So guaranteeing that debt with your house, your car, your bank accounts, those types of things. So we need to be aware of that. And the other thing that happens is, so we're going to be on the hook personally. So if I go into business with Cindy, let's say Michelle and Cindy are going into business together. We open an LLC and we're going to have a new restaurant in Salem. And we're going to lease or buy a space. And so they require Michelle and Cindy not only to sign those documents in the name of the company, but to sign what we call a personal guarantee, make ourselves on the hook for that. What is going to happen is, what if our business goes under in less than a year? Or what if Cindy wants out of the business and I want to keep it running, but she's still stuck on that loan? People jump into these arrangements way too quickly. I see it happen all the time. Somebody wants out of the business or the business dissolves, and then we've got joint owners of real estate stuck without anything in writing on how to get out of it. So Any lease agreement or real estate contract or mortgage or lending agreement that goes with it, those are all legally binding contracts, and we want to be very careful about entering into those. And so we just want to take our time in those things. And a lot of times people are very excited to start their business, and they don't really want to take their time and think those through and negotiate, but we really, really should. Okay. So we talked about, I think number 9 is pretty much a lot of what we talked about already on the lift. On number 10, I think this is an important part to hit, and I do still have a few minutes, so it's perfect. Not having a succession plan in place for your business or an estate plan for your family. So I want to talk about the basics real quick of what estate planning documents are commonly, people are commonly aware of, and maybe what they do, because there's a lot of misinformation out there. So whether you own a business or not, this is good information for everyone to understand. Something is going to happen to each and every one of us at some point in time, so it's good to put a plan in place. The first one we'll talk about is a will. That's one people are most commonly familiar with. However, a lot of people don't understand what a will actually does. So a will is a document that will tell the court what you want to happen to your assets after you die, to your property after you die. So the first important thing about what I just said is a will only helps us if we pass away, so we have to die. A will does not help us if we become incapacitated. So that could be temporary incapacitation, and the example I always give everyone on that is Britney Spears. When she shaved her head and went kind of crazy, her family got control of her assets through court, so then she regained it and got everything back. That could be a more permanent incapacitation. You're in a coma in the hospital, but you're still alive, or unfortunately, Alzheimer's and dementia are getting very, very common. So a will doesn't help us in any of those scenarios, does nothing. The second thing is that a will must be taken through probate court within 1 year of your death for any effect to be given to it. So a will actually requires probate. That means somebody has to step forward and hire an attorney and take that through the court process. And we always talk about, everyone always talks about avoid probate. The big things, the big reasons we want to avoid probate are as follows. Of course, it's expensive. We estimate that it will cost your family 5% of your gross estate, so 5% of your total assets to get through probate. If you have minor children, the costs go up because the judge will have to do some additional things and create a trust for the children to hold the property. The other scary thing with minor children real quick is that if we leave that up to the courts and up to a judge, those children will inherit everything from you at age 18, no restriction. So that's very scary to a lot of people. If you have a home worth $200,000, you're going to have, a child at 18 come into $200,000 to do whatever he or she wishes with it. The other thing is that probate is public. So everyone can watch that process, sit in court, look at the documents, see what's going on. That becomes very scary as well when we have minor children, because that 18-year-old's coming into $200,000. We have people that will prey on that individual. We'll see that going through the court process. The day they get that money, we'll start trying to sell them on every new business opportunity that person can think of and try and scam them out of that money. The other thing is that court takes a long time. If anyone's ever been involved with court, it's not the most efficient process. We estimate 12 to 18 months to get most probate estates through. And the other thing, and that could be a really important thing when we've got somebody who needs our help with healthcare. So if we do not have the right documentation in place and we've got a loved one who needs healthcare decisions made, or that we need to get to the money that's in their bank account that we don't have access to pay for them to have the right kind of care, that becomes a really scary and really sad situation, because we're going to have to wait on the judge to give us permission to get to that money to take care of our loved ones or to be able to make those decisions. The other thing that happens with court is that we lose control. So once we take anything to court, we lose control. A judge ultimately decides. Now, if we've given those basic instructions in a will, then we have left some instructions, but the judge always gets to decide. And there's a story of a father and son, adult son needed to take care of his father. His father got diagnosed with dementia. Father had nothing in writing. He goes and files in probate court to be appointed as guardian conservator to take care of those things. And the judge decided he had horrible credit. He was not responsible with money. He didn't like him and appointed somebody else to make those decisions. So he lost total control of what facility his father was in, what kind of care he received. They drained all the money from the account, and it's just very, very heartbreaking situations like that do happen. So that's why we always want to, everyone always talks about avoid probate. With business owners, it gets even more complicated. Your family does not automatically own your business after you pass away. You have to have the right kind of documentation, and you have to have all owners in agreement and have it documented in writing for those things to occur. And we'll just call those non-probate transfers. The alternative that solves all those things is what we call a trust. And a trust is just an agreement between the person making the trust, who we call the trustor, the person managing all the property in the trust, called the trustee, and the beneficiary. So those would be the people benefiting from the use of that property. So when people are alive and well and they make trusts, they're all three of those in the beginning. And what it does is they manage their property the same way while they're alive. But after they are gone, they already have that seamless plan in place in their trust agreement on who's in charge after they become incapacitated or after they die. And nobody has to go to court. That's the most beautiful thing about it. Nobody has to go to court. It can all be done immediately, and we avoid all of those issues. So business owners is especially important. I have been working with a client for over 3 years now in court fighting about a family business because nobody put anything in writing about who owns what after the original family members died. And so what happens is you end up with 4 different people fighting, 4 different attorneys, 3 years in court, and we're still not done. And how much, you can imagine how much they've paid to the attorneys that could have been left for the family. So when we talk about business succession, that's what we're talking about. We're talking about your personal underlying plan and then incorporating your business into that. It would also take care of that situation that I mentioned earlier where Jack had a stroke and Joe was left running the business and Jack's wife wanted the money. We provide for those instances of incapacity so that we can have a plan in place and we take care of all of that. And that's a piece that a lot of business owners neglect. And then number 11 hits on some more details of not having the right type or amount of insurance. I have dealt with a client recently as well that ended up in litigation because the insurance company they've used for 20 years told them they had coverage on a property, on a commercial property, and they didn't. And they ended up with water damage, and then the insurance company denied coverage. And it gets even worse than that in that they were told they were never getting copies of their policies. When they asked for copies of their policies, they were told certain reference numbers for certain riders were just for internal use. And there's just a whole lot of really sad, wrong things happening in that situation, and they're going to end up fighting it out in court. That instance is where the insurance broker was nothing more than a salesperson. They're collecting their commissions and running to the next person. They do not know what's in their own policies. They don't give people copies of them. And when I sit down with business owners, most people have not read their policies nor do they understand. So if you are not going to sit and read your 50-page policy and try not to fall asleep, you need to find that trusted insurance advisor that's going to do that with you and your legal team as well that will also review and communicate with that insurance person. So we do see that, sadly, every day as well. You will see some other points real quick on that business health check that have to do with websites and email list. So we'll just mention that real quick, and then I think it's question and answer time. There are laws, just be aware, there are federal laws in place that deal with what needs to be on your website and what needs to be, how you need to handle your email list. So we are all familiar with the big major companies. I'm sure we all get spammed daily with a ton of emails from them. If you notice that unsubscribe button at the bottom, that, for instance, is something required by federal law. The big overarching thing to be aware of is just you need to be sure you have permission if you're emailing anyone. That's the big overarching concern there. And then on websites, most people are going to be required either by law or by the terms of their website host or various other requirements to have what we call a privacy policy on their website and a terms and conditions on their website. And if you look at some of the major websites that you visit all the time, you're familiar with, you can kind of see what I mean there. Those are contracts that are going to govern how people visiting your site are using the site and any information on it. They are really a protection to the business owner. So I really, really, really encourage everyone to have a privacy policy and terms and conditions on their website. It forms a contract between your company and the user, and it really provides a lot of protections to the company. So I think that's about good to at least allow some time for questions if there are any.
All right. Can you hear me okay?
Yep.
All right. So let me see if I can unmute everyone. I think some people have to unmute themselves. Does anybody have any questions? I don't have any in the chat.
We do.
Okay, go ahead.
Okay. I've got a couple I can put out there. If it's okay.
I think there's somebody who has one. I know one of the.
Did I see a hand? Is there a hand?
We have one here in Aurora, a question. Can you hear us? Okay.
Yep. My husband has a business on the side as far as maintenance that he just kind of operates out of the home. And wondering about building a shop to store some of the things like he mows yards, does asphalt ceiling, all of this stuff. So would that be something that we would build it out of our personal funds because it's on our personal property because we own 5 acres, and then he pays rent to us personally, or what do you recommend?
So I have to give my disclaimer, and I should have actually given it in the beginning. I cannot give specific legal advice to anyone's situations unless we were having a conversation where you've agreed to be bound by attorney-client privilege and that we've agreed I'm going to be doing that. So I cannot specifically answer your situation, but I can give a general answer, okay? So this is not specific legal advice to anyone, but let's talk about that commingling because that's kind of a common thing. If somebody is using their home for business purposes in any way, it happens all the time. That's one of those areas you need to be really cautious about consulting with a tax professional who knows what they're doing, a CPA, because they're going to tell you one thing on what can you write off on taxes. And you also need to be consulting with an attorney who knows what they're talking about, because we are going to walk you through and make sure we have those clear lines drawn between what's business and what's personal. So it could involve, it's going to make sure the first thing is going to be that we have all your business structures in place, that operating agreement, that the bylaws if you're a corporation, we've got all those things in place and you're maintaining them. The second thing is going to be any kind of agreements between the company and you personally. So it could involve a lease agreement. It needs to be written. We need to have the money going back and forth in the right way. We need to have insurance policies adjusted. I mean, that's one of those ones where if you're going to, for instance, build a shop, it's really tricky. We're going to have to, a lot of times we actually parcel out that land separate so that we can have different insurance policies and we can have the lease agreement actually pertain to that specific piece of property, and it is fairly complex. So it is something that can be done and is done frequently, but it's not often done correctly. So it's definitely something you're going to want to talk to my office or somebody else on the legal side, and make sure that you've also got a tax person who understands enough to trigger what's legal. If you go to the majority of accountants, they're probably going to say, sure, here's the portion you can write off, and they're not going to trigger the legal side of that for you. So that's a perfect example of when we run into some of those situations. Did that at least give you some guidance?
Yes.
Okay.
Can you also tell me, so is this presentation recorded that we can watch? Okay. Yes. And then you mentioned the S&T information.
Yeah. I can send that in the follow-up. If you Google them, so Missouri S&T here in Rolla, if you Google, I'm trying to think of, I've done talks with them and I do help them sometimes with their programs. They have, I'm trying to think of the actual word, Technology Development Center, I believe is maybe the formal term of that office. But if you Google, it's an entrepreneurial and technology development center, something of that. And Karen Leatherman is one of their contacts there. So if you Google her name at S&T, I'm sure you could find her. I will also give that information to the chambers and they can email that out to everyone. Oh, it's called I think it came to me. I think it's called the Small Business and Technology Development Center. I believe that's correct. So you should be able to find them online, but I'll also include that if you want me to send that out. They help people develop their business plans. So they also help with various funding options that may be available through government agencies. So it's a good resource there. They do not handle the legal. So sometimes they will have me talk just on basics like I am today without providing any direct legal advice to anyone in particular. And then, you know, they will refer people to myself or other legal advisors around if there are any specific topics, but they're perfect on getting that business plan together, figuring out financing, figuring out if it's financially going to work.
Hey, Michelle.
Mm-hmm.
Michelle, hi, this is Karen Leatherman with the
Small. Are you there?
Development Center.
Karen, tell them.
Yeah, we're in Salem with Tabitha. So.
Oh, okay. I can't see who's there, so I can't see if you are in the video. Okay, there you are. So Karen's here.
So yes, anybody can reach out to either me or my colleague Traven Shelton, and if you search for Small Business and Technology Development Center Rolla, you should find us. Or you can contact Michelle and she'll put you in touch with us as well.
Sure. Perfect, you were there. And I think the name came to me after a few minutes, but anyone else have any other questions?
Michelle, let me put one or two out there for you. Hopefully these are quick answer questions. You mentioned documentation. Is there any distinction between hard copy and scanned documents as far as having information saved?
So we do have, okay, a couple of points there. We do have a law. We have a federal law and a state law that allow for electronic signatures if they're done in the right way. So that's kind of one piece of that. When you are coming in, if anything ends up in litigation, there's what we call the best evidence rule, which means that an original is best. And so, but there are ways you can use copies. So the way to really protect from that, if you're going to, for instance, store your documents electronically and not keep total paper copies of everything, is to make sure you just put in those writings that a copy you intend for the parties to be able to sign in what we call counterparts so that they could sign at different times, that an electronic signature should be valid, and then a copy would be valid as well. So that's just something I usually have in my contracts to kind of catch all of those areas. And usually we don't have a problem, but that kind of touches all the bases in case you were concerned about an original versus a digital copy. And actually, if anyone's dealt with realtors in Missouri recently, I think the great majority of them, if not all of them, are using electronic signatures even on those real estate contracts. So they are acceptable.
Okay. Next question. You mentioned not mixing owners and personal expenses. Are there any types of expenses that are customary that might carry over that wouldn't raise a red flag? Like maybe health insurance premiums or something like that? Or is that pretty much everything's off base?
So, well, and real quick before I confuse someone on my last statement there, electronic signatures are valid as long as you meet the requirements of verification that we have in law. But anyway, so they can be valid, like the real estate ones are valid. I just kind of caught myself on that. Somebody might take that the wrong way. So you can't just go on and type your name and, you know, we might have an issue there. But on your next question about the expenses, so healthcare in particular, I'll just use that for an example and see if, because I'm not sure I totally understand your question, but let's see if this addresses it. So if there's two ways to have health insurance. One is you can have an individual policy where, so I, Michelle, having a policy for my family. My company has nothing to do with it. My company's not paying anything towards it, you know, totally individual. The other way is to have the company have the health insurance policy. So they'd own the policy. They would actually pay, the company pays let's say it's Anthem, they'll pay them directly. And there are requirements, just to be aware, if you are a business owner and you have your company having a health insurance policy available, there are requirements that on those policies. So if a company offers health insurance to anyone, even if it's the owner, they may be required to offer it to other employees, and there are certain restrictions on that. So just be aware, if you have your company paying for it and have a policy on you, you may then be required to get policies for your other employees. So the way that we avoid that commingling would be, if I have a policy as Michele individually, I cannot have MK Legal Planning pay my health insurance. So MK Legal Planning has to give me a paycheck or give me a distribution, or what we call a member draw. There's a couple different words for it. It has to give me money first, and then I have to use that money to pay my health insurance. So we have to have that paper trail, even though it seems silly. And that's the hard thing for business owners to get in the habit of doing, and all it really is developing a habit. You know, we're also ingrained in our businesses that we feel like it's our baby and we feel like it's one and the same. We have to go through and make that extra paper trail. So if the company has the policy, then it would be an MK Legal Planning has health insurance for its employees. Michele is one of the employees, and then MK Legal Planning is paying my health insurance. The tax of that will be different, right? That could be another situation where you just give a number to your accountant on, here's what the company spent on health insurance, or here's what I spent individually. They're going to figure out how to write that off for you. They're not necessarily going to trigger for you if you're commingling one or the other. But that's that paper trail we want. So anything that's individual, you know, an individual name or an individual bill, like health insurance, a car payment, a house payment, my cable bill at home, that kind of thing, you have to show that paper trail where the company needs to pay you in some form. So it goes from company account into your personal account, and then you're writing a personal check to whatever bill you're paying, or doing, you know, a payment from your personal account to whatever bill it would be. I know a lot of people do the online or direct payments. Did that kind of answer what you were talking about?
It absolutely did. Thank you.
Okay.
All right. Well, I think we're ready to wrap. So I'm going to put up your contact information. Let's just make sure that I actually got that correct. Does that look good?
Yes. And
Michele?
then, yeah. And then I have, oh, nope. The phone number is 573. So the area
573.
573-578-2848. And everything else looks good. And then there is, if anyone, I do have a weekly email newsletter that goes out to business owners that has some of those articles that we mentioned, and just kind of keep everyone on topic. And that's free. So if anyone wants to be added to that, I don't know. I have to look at my, here we go. Let's see. Here we go. Then I have a address for that too. And it is mklegalplanning.com/subscribe-now-2, and I will send that to everyone on email too, on so the chambers can send that out in case anyone wants to be added to the email.
Perfect. All right. Well, thank you, Michele. We appreciate your valuable information. And if there's no other questions, I want to thank everyone for attending. And it looks like we wrapped up just on time. So thank you very much.
Thanks, everyone, for having me.